after the information they had gathered and after they presented their PowerPoint presentation to the prosecutors. Against that truth of how we got here, I want to address the privilege log that we suggested would be an efficient way for this court to tackle this bear. The question that this begets is, how in the world are we to ascertain who hit the ground running interview or what they collected if they're not willing to tell us? Well, the very prudent way that is often employed in civil cases is a privilege log. Could not be a more simple way to pare this down, give us a target to shoot at, and give His Honor an idea of why this might be privileged and why this might not be in a very efficient manner. That's why we made the suggestion. I reached out to these very fine lawyers a month or so ago and asked them what they thought about a privilege log. I didn't hear back from them, but they've made their position clear in their papers. As I was getting packed up to come out here, one of my boys was helping me, and he asked me what this hearing was about, and I told him. And he saw my binder here, and he said, "Can I read some of it?" Absolutely. So he started reading the papers of Hit the Ground Running, and he asked me a few questions. What does materiality mean? Did my best to explain it to a 12-year-old. Well, what about relevance? Again, I tried to. He went back to the brief and read a little bit more, and he posed a question that I think encapsulates what we're asking about better than anybody. He said, "Dad, how can you tell if the information is relevant if they won't tell you what they have?" Simple enough for a 12-year-old to get it. These are very, very capable First Amendment lawyers, and they have done a yeoman's job of preventing the disclosure of information that Hit the Ground Running does not want to share. Now, that being said, they know their opposition to a privilege log has no legal precedence. Neither is our position asking the court to. It lies within this court's very sound discretion in looking at this and saying, look, fundamental fairness here. How can we go about this and make sure that we don't compromise Mr. Durst's right to a fair trial? The next thing I thought of was this kind of evolving argument that we've heard from the Hit the Ground Running producers. Through Mr. Lewin, who I trust always represents things accurately to me, we were told there were about 50 recorded interviews. Those recorded interviews were imaged by the FBI, turned over to the people turned the same over to us. We later learned that there were actually 54 recorded interviews. We were told we had them all. But as this story evolves, I learned from Mr. Jarecki himself that there are at least 3 more interviews out there, recorded interviews. And it's a very important distinction here. I keep saying recorded interviews for a reason. But Mr. Jarecki wants us to believe these 3 recorded interviews that we don't have are of no moment. In fact, his own words, Your Honor, quoting Mr. Jarecki, "We have produced the overwhelming majority of the recorded interviews conducted for purposes of the Jinx." I get very nervous when I read that, Your Honor. There are a lot of qualifiers in there. Recorded interviews for purposes of the Jinx. There are far too many qualifiers in that little sentence to trust it. Mr. Jarecki goes on to explain the remaining recorded interviews are comparatively peripheral. I had to ask my son what comparatively peripheral meant because it was a bit confounding. But these quotes really do reflect the problem, Your Honor. The wordsmithing alone makes a lawyer in charge of ensuring Mr. Durst gets the fairest trial he can get quite nervous. It makes me wonder, what are these very well-crafted words designed to hide? And let's go back to my arguments in the agency context, because they come to bear right here. And the part of it that comes to bear is the part that the court accepted is we have, without question, established Hit the Ground Running's motive in the production of this television series. given their motive was clearly, on the one hand, to promote their cinematic piece, they saw it as incumbent upon them to further that motive with the second motive of getting Mr. Durst charged. I quoted you time and time again, Mr. Jarecki, Mr. Smerling's own words that established beyond peradventure, during that project they decided they needed to get Mr. Durst charged with murder. Therefore, given that motive, their credibility here has to be put in the proper light. They continue to represent themselves as journalists.
Your Honor, I apologize. I don't mean to interrupt you, Chip. There's a witness who is in here that I meant to advise the court of. Doug Oliver, Mr. Durst has talked about calling Mr. Oliver as a witness. He is in court right now. We're going to ask that he be excluded and asked to step out. I made the request to him prior to the court taking the bench. He is still in the courtroom. I was going to ask the court, Your Honor. The defense has indicated that he is going to be a witness for them. It is possible we are going to be calling him as a witness, and it's therefore inappropriate for him to be listening to arguments regarding either this issue or handwriting, etc.
I didn't know the rule applied to a non-evidentiary hearing. It's a public.
Right. So ordinarily, the idea is to prevent witnesses from hearing each other's testimony. That's been it can be extended, well, particularly when you're arguing about that particular witness's testimony, and there might be some hint to the witness from the argument that the witness ought to shade his testimony in one way or another. For example, in a suppression motion. That being said, there is that right to a public trial. That's where the tension is, and also, of course, you have the right to cross-examine that witness on his presence at this very hearing, to the extent, and that may be effective to reduce the credibility of testimony under the circumstances. Perhaps, though, because it's controversial, this witness would choose to step out. I don't know. You've asked him, and he has not been.
Mr. Oliver seated in the white with the ascot, Your Honor.
I see. Yes. All right. The gentleman's there in the front row. Well, overruled. You may continue.
Thank you, Your Honor. Mr. Lewin took 3 minutes of my time to make that airplane. I'm going to hold that against you.
You'll make it. I don't know if you'll hear the ruin.
That's fine. Mr. Chesnoff, Ms. Bain, and Mr. Ray will, and our very capable court reporter, I will read. The journalist, Merriam-Webster's defined a journalist as a person who collects, writes, distributes news or other current events to the public. What do journalists not do? Journalists do not interview folks, edit their material, piece it together to produce their motive, tease the suspenseful conclusion of their work for their dramatic series. Journalists just report the facts. They do not manipulate the facts and try to pass them off as the truth. And then embark on a national-wide media blitz of self-flagellation. Their victory lap at the conclusion of the Jinx and Mr. Durst arrest was halted only because of a very wise suggestion of one law enforcement member who called Mr. Jarecki and suggested, hey, you might want to shut up. You're now the primary witness in a murder case when the man you got charged with murder faces the death penalty. Your Honor should exercise the proper discretion in this area. You have all the discretion in the world as both hit the ground running and we have cited for you. Relative to the refrain in the hit the ground running papers about the burdensome, costly inconvenience to the producers. I'm not going to shed many tears for the producers, Your Honor. They made millions off of getting Mr. Durst charged with this murder case. Incumbent upon that is the obligations that our Constitution is going to put truthful and credible information before the jury. Their goal was not further cinematic suspense, make this, quote, a lot more damning than it really is when viewed as it actually was said. This motive that flows from the gathering of information, the making of their movie, to getting Mr. Durst charged, didn't die when Mr. Durst got arrested. It's the same motive they have in resisting the discovery prior to trial. All the articles do, Your Honor, is they illustrate the fact that there is, in fact, debate, controversy over the propriety of the editing we've talked so much about. We're not offering for the truth of the matter asserted, whether it was proper or improper. We're not journalists. I'm not a film critic. Good for Mr. Jarecki. But what this court is called upon now in ensuring Mr. Durst has a fair trial is looking at the fact that they did have a motive for their actions. Their motive makes it suspect as to why they have not produced certain things, what might be out there, and this is why the court should take judicial notice of that. I will say this lastly on judicial notice. Unless they finally want to honestly admit that the editing was misleading, as everyone else has concluded, as the people have told this court, they wouldn't do that because that is not the truth of Mr. Durst's statements in that instance. Then the court can properly take judicial notice of this to establish for the court, for our purpose of motive, not for the truth of the matter asserted. Last part before I conclude, Your Honor. Having been tasked with this all things Jinx in this aspect of the case, I have come to know quite a bit about the producer's history. And frankly, there is a very concerning pattern here of manipulation for the benefit of cinematic success. In a previous project, Capturing the Freedmans, I don't know how familiar Your Honor is with this factual matrix, but Mr. Jarecki produced a picture about two Freedmans. There were two men who were wrongfully framed by law enforcement and forced into pleading guilty to crimes they did not commit. That was his premise, that was what his movie was about, that was the conclusion. However, less than a year after the film's release, a plethora of inculpatory evidence surfaced. It became apparent that Mr. Jarecki had intentionally omitted an interview of Jesse Friedman, wherein he admitted his guilt, detailed his involvement in the abuse of children with his father's assistance, over 17 children ages 9 to 11. He also intentionally admitted the existence of a third co-defendant who had admitted guilt and went to prison for his involvement in the crime. Law enforcement and the victims of the Freedman's offenses were up in arms. And consistently, they all wondered, why did Mr. Jarecki twist the truth? Why did he ignore things that he knew were contrary to his conclusion? The filmmaking methodology present with the producers of the Jinx demands that we scrutinize as we have and continue to scrutinize to ensure there is not information out there. I fear, Your Honor, the reason Mr. Jarecki uses recorded interviews repeatedly when he refers to any of this is, what about the interviews they didn't record? They didn't record them because they didn't fit their theory. But they have notes, they have conversations that are memorialized, they have evidence of these other interviews that could be either exculpatory or produce impeaching information about other interviews. We can't take that chance. And here's why, Your Honor. If this court allows hit the ground running to suppress the requested information that we need to properly defend Mr. Durst, we're going to start down a very perilous path. And it's my prediction it goes something like this. We spend weeks, if not months, picking a jury. We get into our second month of testimony. The people call one or more of the producers, as they said they will. Under vigorous and proper cross-examination, we all learn that indeed there was other material out there that they didn't disclose. And in fact, this other material does bear on the innocence of Mr. Durst. It does impeach other witnesses that the people have called. It should have been provided a long time ago so the defense can make effective use under the Sixth Amendment's guarantee that Mr. Durst will receive effective assistance of counsel. Then the court gets to declare a mistrial or grant a lengthy continuance to ensure the trial remains fair, as this court will insist. The jurors that have sacrificed so much of their lives have done so for naught. The millions in taxpayer dollars that the good folks of California have put forth have been wasted. Having gotten a great sense of this court and this court's rectitude, I know this court's way too wise to go down that perilous path. We ask your honor simply to do one thing: do the right thing. Make sure they give us everything that they should. We suggest that the most efficient way to do that is to grant a privilege log. Let us work with hit the ground running parties. They will tell you I'm very communicative. I've answered every call, every email, make myself available whenever they need to talk. Perhaps we can narrow this privilege log, narrow the universe so the judge knows what we're fighting about and so that we have a fair target. We shouldn't allow this third party, and they're not a true third party in the sense of many of the cases that His Honor studied. This is far different kettle of fish. They are the reason we're here. It is their work, is the only reason we're here. They can't be allowed to force us through a trial of subterfuge or cherry picking what we'll see and what we won't see. They cannot use the journalist privilege, the journalist shield, as both a sword as they did in their cinematic adventure, and then now come in here when Mr. Durst faces his life, a death penalty case, and try to use that same journalistic privilege as a shield. That's just not fundamentally fair, Your Honor. We ask you to grant us all the relief this court believes is we are entitled to under the law and in this court's sound discretion. Thank you, Your Honor.
Thank you, Mr. Lewis. Before we take our lunch break, we do break at 12 o'clock for various reasons. In my haste to hear Mr. Lewis's argument, I neglected to ask for the appearances of counsel for the real party interest. Will you state your name for the record?
Yes, of course. I'm Linda Steinman of Davis Wright Tremaine. I'm here to represent Hit the Ground Running, and this is my colleague, Dan Laidman of Davis Wright Tremaine.
Thank you. And what have you done with Mr. Kaufman? All right. You can answer that question at 1:30 when we return, but we'll be in recess until that
Thank
time.
you. Rest assured he's fine. Mr. Connor is very well.
Okay.
Thank you.